It finally happened, and the moment it did, the entire courtroom understood that a line had been crossed that could never be uncrossed again. What you're about to hear is not exaggeration, not courtroom drama, and not a moment staged for cameras. This was a federal judge reaching the absolute end of his patience and exercising the full weight of his authority without hesitation. Judge Caldwell, known for decades of restraint on the federal bench, issued an order so direct and final that even seasoned court observers were stunned. No warnings were repeated, no second chances were offered, and no delays were tolerated. In a packed courtroom, with cameras rolling and attorneys frozen in place, he ordered federal marshals to remove the defendant immediately. The marshals moved before the final word even left his mouth. And then came the part no one expected, the decision that turned a tense removal into a historic moment. Bail was denied on the spot. Not later, not after another hearing, right there in real time. This wasn't performance or posturing. This was a judge making it clear, publicly and unmistakably, that enough was enough. When a sitting federal judge looks directly at armed officers and says, "Remove him now," the legal system has reached a breaking point, and something irreversible has just occurred. Everyone watching knew it instantly. This was no longer just another contentious hearing. It was a declaration. And now, here is exactly what led to that moment and why the legal world can't stop talking about it. What triggered this extraordinary escalation wasn't a single outburst pulled out of context, but a calculated response to behavior that Judge Caldwell had already warned would not be tolerated again. The hearing itself was supposed to be routine, a standard pretrial proceeding that typically moves quietly through procedural checkpoints. Instead, it became the culmination of months of mounting tension. Judge Caldwell, whose reputation for patience spans decades, witnessed conduct that shattered even his long-standing restraint. This was not just another viral clip of a judge raising his voice. This was a deliberate, measured decision by a federal judge to invoke the full extent of his authority while the entire legal community watched in real time. The defendant, already known for testing boundaries during prior appearances, crossed a line that had been clearly drawn and repeatedly emphasized. What unfolded over the next 90 seconds is now being analyzed by legal scholars across the country. Former prosecutors have described it as a textbook demonstration of judicial control. Defense attorneys, meanwhile, are calling it one of the most sobering moments they've ever seen play out in open court. And what makes this moment even more significant is that the removal itself was only part of the story. The real shock came with what followed. Because when a federal judge revokes your bail mid-hearing while marshals are already escorting you away, your entire defense strategy collapses instantly. To understand how it reached this point, you have to look at what happened inside that courtroom from the very beginning of the hearing. The session began at precisely 10:17 a.m. And according to multiple courtroom observers, the defendant entered with an attitude that immediately set the tone. Witnesses described visible contempt, a refusal to acknowledge the judge, loud whispering to his legal team, and even moments that appeared to be laughter during procedural remarks. These details matter because federal courtrooms operate on decorum and respect. And every person in that room recognized the warning signs. After handling preliminary matters, Judge Caldwell turned to the issue of compliance with pretrial release conditions. That's when everything changed. The defendant interrupted him, cutting the judge off mid-sentence. According to reporters present, the defendant declared that the court had no authority over him and that he did not recognize the proceeding at all. The room went silent. Judge Caldwell paused, allowing the weight of the moment to settle. He offered one opportunity, and only one, calmly stating that the defendant would conduct himself with respect or face immediate consequences. Instead of backing down, the defendant reportedly turned toward the gallery and made a dismissive gesture in the direction of the bench. That single act became the trigger that ended everything. Judge Caldwell's voice did not rise, but witnesses say it turned unmistakably cold as he issued the order that changed the case forever. As soon as the words left Judge Caldwell's mouth, the atmosphere inside the courtroom shifted in a way that seasoned observers say they had never experienced before. When he stated, "Marshals, remove this individual from my courtroom immediately. We are done." There was no hesitation and no confusion about what was happening next. Two United States Marshals positioned near the side entrance moved instantly, closing the distance between themselves and the defendant with practiced precision. The defendant barely had time to register what was unfolding before he was being physically escorted toward the holding area. But the removal itself was only the beginning. Judge Caldwell was not finished, and he made that clear while the marshals were already in motion. Speaking calmly and deliberately, he directed the record to reflect that the defendant had demonstrated willful contempt for the authority of the court. Then came the decision that stunned everyone present. Based on that conduct, combined with documented violations of pre-trial release conditions, the court was revoking bail effective immediately. This was not a theoretical ruling or a promise of future consequences. The defendant's freedom was terminated in real time, in full view of the courtroom, as he was being escorted out. Legal analysts reviewing the transcript later emphasized that this was not an emotional reaction. It was a calculated judicial action supported by a detailed record that had been building for weeks. Judge Caldwell cited specific and concrete violations to justify the immediate revocation. These included missed check-ins with pretrial services, alleged contact with witnesses despite a clear no-contact order, and social media activity that appeared to target or threaten court officers. According to court documents, the defendant had failed to attend 3 scheduled check-ins over the previous month alone. Pretrial services had already filed 2 formal notices of noncompliance, both of which had been addressed in earlier hearings with explicit warnings from the bench. Those warnings, however, lost all relevance the moment the defendant chose to interrupt the judge and openly challenge the court's authority. Within an hour of the incident, the bail revocation order was formally filed, and the language in that document immediately drew attention across the legal community. Judge Caldwell wrote that the defendant had demonstrated a fundamental unwillingness to comply with the conditions of release and had shown contempt not just for the court, but for the judicial process itself. He concluded that continued liberty posed an unacceptable risk to the integrity of the proceedings. Legal professionals noted that this phrasing is rarely used and signals a judge who is fully confident in the strength of the record supporting detention. As more details emerged, it became clear that the courtroom confrontation was only the final piece of a much larger puzzle. According to sources familiar with the case, investigators had been quietly building a foundation for bail revocation long before the hearing took place. Despite being ordered to limit public statements related to the case, the defendant had continued posting on social media in ways prosecutors argued amounted to witness intimidation. One post referenced individuals believed to be cooperating with the government using only their initials, paired with language that the prosecution described as thinly veiled threats. Judge Caldwell addressed this conduct directly in his written order, stating that the defendant's public communications reflected not just poor judgment, but a calculated effort to undermine the administration of justice. Former federal prosecutor Marcus Webb told legal analysts that the depth of documentation suggested the judge was not caught off guard at all. In his assessment, the court had been waiting for the right moment to act. This was not an impulsive reaction. The revocation order was already prepared, and the defendant's behavior in the courtroom simply provided the final justification needed to enforce it. The result is that the defendant is now being held without bail pending trial, a status that is extraordinarily difficult to reverse in federal court. His legal team now has a narrow window to file an emergency appeal, but the odds are steep. With the defendant now in federal custody, attention quickly shifted from the shocking removal itself to the deeper history that made Judge Caldwell's decision not only possible, but arguably inevitable. This confrontation did not appear out of thin air. It was the result of months of escalating tension driven by a consistent pattern of boundary-pushing behavior. From the beginning, the defendant treated court appearances less like formal legal proceedings and more like opportunities to challenge authority and draw attention. That pattern became impossible to ignore 3 months earlier during a hearing that, in hindsight, set everything in motion. According to official transcripts from that session, the defendant openly questioned whether Judge Caldwell even had jurisdiction to impose pretrial conditions. The claim had no legal basis, and the judge dismissed it immediately, but not without leaving a warning on the record. He stated clearly that the court's patience should not be mistaken for weakness and that the latitude being extended could be withdrawn at any time. That warning, precise and deliberate, would later take on far greater meaning. Instead of adjusting his behavior, the defendant appeared to interpret the judge's restraint as a lack of resolve, a miscalculation that would prove costly. In the weeks that followed, pretrial services began documenting what they described as a steady pattern of technical noncompliance. Check-ins were late, sometimes by hours and sometimes by days. Information about the defendant's whereabouts was incomplete or vague. Required forms were submitted, missing signatures or key details. Taken individually, each violation might have seemed minor, the kind of issue that could be corrected with a reminder. But federal judges do not look at violations in isolation. They look for patterns, and this one was becoming increasingly clear. 6 weeks before the dramatic removal, Judge Caldwell addressed these concerns directly during another hearing. According to the transcript, he placed the defendant on formal notice, stating that any further documented violation would prompt him to seriously consider revoking bail. The defendant's attorney assured the court that compliance would improve and that the issues were being addressed. That assurance, however, was not matched by the defendant's actions. The violations continued and the record grew longer. 2 weeks later, the situation escalated further when pretrial services flagged the defendant's social media activity. Despite explicit instructions to avoid public commentary related to the case, the defendant posted messages that prosecutors argued came dangerously close to violating a protective order. While the posts stopped short of explicit threats, they referenced the case and individuals connected to it in ways that raised serious concern. When prosecutors filed a formal motion seeking bail revocation, they did not rely on speculation. The filing included screenshots, timestamps, and analysis asserting that the posts were designed to intimidate potential witnesses. Importantly, the hearing where the Marshals ultimately moved in was scheduled specifically to address that motion. Judge Caldwell had already reviewed the evidence, and court security arrangements reflected that preparation. The Marshals were positioned deliberately because the court anticipated the possibility of confrontation. What the defendant failed to understand, and what his legal team may not have fully conveyed, was that he was walking into a courtroom where every scenario had been anticipated. When he interrupted the judge, he wasn't provoking an unprepared response. He was activating a plan that had been built carefully and patiently over time. The most striking detail reported by witnesses was that even as the Marshals approached, the defendant did not stop speaking. According to multiple accounts, he continued addressing the courtroom, suggesting that he could not be silenced and implying that the public would see through what was happening. That refusal to disengage only deepened the consequences. Judge Caldwell immediately directed the record to reflect that the defendant continued to disrupt proceedings even while being lawfully removed. He stated that this conduct would be considered in future sentencing should there be a conviction. The courtroom, according to reporters and legal observers, fell into a near total silence. One court sketch artist with more than 2 decades of experience covering federal proceedings later said she had never witnessed authority exercised so decisively without a raised voice. As the defendant was escorted through the side door and attempted to turn back toward the gallery, the Marshals physically redirected him and closed the door. Without pausing, Judge Caldwell addressed the remaining attorneys, announced a brief recess, and stated that the court would resume with other pending motions. The moment was over, but its impact was just beginning, and what happened in those 90 seconds was already echoing far beyond that courtroom. As the immediate shock wore off, legal experts across the country began placing Judge Caldwell's actions into historical context, and that's where the moment took on even greater significance. This was not the first time a federal judge had ordered Marshals to remove a disruptive defendant, but the way this unfolded made it fundamentally different from past examples. Observers quickly drew comparisons to the 1969 Chicago 7 trial, where Judge Julius Hoffman, overwhelmed by constant disruptions, ordered defendant Bobby Seale to be bound and gagged in the courtroom. That decision was later widely criticized and became a symbol of judicial overreach, with Seale's conviction ultimately overturned. Judge Caldwell took the opposite approach. Rather than attempting to continue proceedings with a disruptive defendant present, he removed the source of disruption entirely and immediately addressed the broader risk posed by continued pretrial release. Another comparison emerged with the 1,988 case of tax protester Irwin Schiff, who repeatedly challenged federal judges with claims that income tax laws were unconstitutional. Schiff was removed from courtrooms and restricted in his filings, but even in that extreme case, bail was not revoked solely based on courtroom behavior. What sets Judge Caldwell's decision apart is the combination of immediate removal and bail revocation delivered as a single ruling, supported by an extensive record. Legal scholars have been focusing on that combination with intense interest. Professor Sarah Chen, who teaches criminal procedure at Georgetown Law, explained that in most cases, removal for contempt and bail revocation are handled as separate matters. A defendant is removed to restore order, and a separate hearing is later scheduled to determine whether detention is warranted. Judge Caldwell collapsed both processes into one decisive action, and crucially, he had the documentation to support it. His written order did not rely solely on the outburst in the courtroom. It cited weeks of accumulated violations, prior warnings, and documented conduct that collectively justified immediate detention. This approach reflects how experienced federal judges operate. They do not act on impulse. They build records, even against defendants appearing before them, so that when authority is exercised, it is legally defensible. By allowing the consequences to arrive all at once, Judge Caldwell sent a message that resonated far beyond this single case. Former federal prosecutor Marcus Webb described the move as textbook but elevated. He noted that prosecutors are trained to build a record before making a major move, and Judge Caldwell clearly did the same. The difference here was the confidence required to execute both removal and bail revocation in real time, knowing the decision would be scrutinized by appellate courts and the broader legal community. According to Webb, the defendant's legal team now faces an almost impossible challenge. To succeed on appeal, they would need to show that the judge acted without sufficient cause, yet the record shows repeated warnings, documented violations, and conduct that any reasonable judge would find unacceptable. Constitutional law professor David Armitage from Harvard Law School highlighted the broader implications, emphasizing that federal courtrooms are not platforms for political performance. Defendants do not have a constitutional right to disrupt proceedings, and Judge Caldwell made that reality unmistakably clear. Even defense-oriented analysts, while cautious about the potential for misuse in less clear-cut cases, acknowledge that the defendant's behavior here was extreme. Former public defender Natalie Reyes, now a legal commentator, described the situation as a textbook case of self-inflicted damage. She noted that no attorney could have prevented the outcome once the defendant chose to act the way he did in that moment. Observers also pointed out the visible distress of the defense attorney during the removal, a silent acknowledgement that the situation had spiraled beyond any lawyer's control. What further strengthens Judge Caldwell's position is the clarity and thoroughness of the written record. The 11-page order filed within an hour of the incident detailed every missed check-in, every questionable social media post, and every warning issued in prior hearings. Retired appellate judge Patricia Hammond remarked that such an order is not written in an hour from scratch. It was prepared in advance, not because the judge wanted a confrontation, but because he anticipated the possibility and ensured the court was ready. This, she explained, is the difference between a reactive judge and a strategic one. And it's why this moment is now being discussed as a potential turning point in how federal courts handle defiant defendants. What this all means going forward is where the consequences truly begin to unfold, because the effects of Judge Caldwell's decision extend far beyond a single defendant or a single courtroom. First and most immediately, the defendant now faces pretrial detention that could last months. In the federal system, detention pending trial is notoriously difficult to reverse. Appeals courts give substantial deference to a trial judge's discretion, especially when the record reflects repeated violations and clear warning. Any appellate panel reviewing this case will see the full transcript, the documented noncompliance, and the defendant's own courtroom conduct preserved word for word. The defense is expected to argue that revoking bail based largely on courtroom behavior is excessive. but prosecutors will counter that this was never about a single incident. It was about a pattern demonstrating that the defendant could not be trusted to follow court orders. With the courtroom disruption now part of the permanent record, that argument becomes even harder to overcome. Beyond this individual case, the decision is already changing how defense attorneys nationwide are advising their clients. Federal public defender offices and private defense firms alike are updating guidance, making it explicitly clear that courtroom defiance carries immediate and severe risks. Judges have authority, and when that authority is tested repeatedly, it will be enforced. Sources familiar with defender training programs indicate that attorneys are now being instructed to formally document warnings given to clients about courtroom behavior. That documentation serves a critical purpose. If a defendant ignores counsel's advice and disrupts proceedings after being warned, responsibility shifts squarely onto the defendant's own choices. Judge Caldwell's actions have made that reality impossible to ignore. The message is clear. Federal court is not a stage, and treating it like one can end your freedom instantly. This case also establishes a practical precedent for combining removal and bail revocation when the record supports it. Prior to this, many legal practitioners assumed these steps would occur separately. Judge Caldwell demonstrated that existing authority already allows both actions to happen simultaneously when justified by documented conduct. Legal scholars are now debating whether this represents an expansion of judicial power or simply a clearer illustration of powers that have always existed. Professor Chen has suggested it's the latter, arguing that the authority was always there but rarely exercised so decisively and publicly. For defendants on pretrial release, this changes the calculus entirely. Every missed check-in, every questionable public statement, every ignored instruction now builds a record that can be activated instantly if courtroom behavior deteriorates. The consequences no longer arrive in stages. They can arrive all at once. The ripple effects extend even further when looking at the defendant's response after the removal. Within hours, statements from supporters began circulating online, attacking Judge Caldwell personally and framing the decision as persecution rather than addressing the documented violation. Some posts, now preserved by prosecutors, accused the judge of tyranny and questioned the legitimacy of the court itself. Legal analysts quickly pointed out how damaging this approach is. When a defendant has already demonstrated disregard for judicial authority, continued attacks only reinforce the court's findings. Prosecutors are closely monitoring post-removal statements, and anything that crosses into threats or witness intimidation could result in additional charges. The defendant may be in custody, but the actions of those speaking on his behalf continue to shape the case in ways that are almost certainly unfavorable. At its core, this moment is about more than bail or courtroom decorum. It's about whether the rule of law can function when defendants attempt to turn legal proceedings into acts of defiance rather than processes of justice. Federal judges confront this challenge regularly, and Judge Caldwell's response sent an unmistakable message. Courtrooms have rules. Judges have authority. When those boundaries are tested repeatedly, the system will respond decisively. The image of marshals moving in without hesitation and a judge revoking bail in real time will now be studied, cited, and remembered. Every defendant awaiting trial in federal court has seen what happens when patience runs out. Judge Caldwell answered a question that many courts quietly face. Do the rules actually apply when challenged? In this case, the answer was clear. They do. The defendant is in custody. The record is complete. And the precedent has been set